Good afternoon, everyone, and thank you so much for joining us for the MVL Mastering Your Insecurity, CLE. We are really excited for these wonderful speakers today. I am Tony Ann Nunes. I am the Director of Metro Volunteer Lawyers and the Pro Bono at the CBA and DBA. A couple of housekeeping matters. If you are not muted, please make sure that you do that. Feel free to leave your cameras on or off. And as you can tell, we are recording this. We will make sure that it's posted to our website in the future. So again, thank you all. We will have 3 separate speakers today talking about different issues. And so we are asking everyone to hold their questions until the end. However, please feel free to put those questions in the chat and we will monitor the chat and answer those questions at the end of the presentation. So again, thank you all for joining us and thank you to our wonderful speakers for helping us get this going. As always, MVL is looking for volunteers. We do this to help train our current volunteers, to help reinforce them, and also to bring on new volunteers. So if you know anyone that would be interested in doing any work at MVL or any work in the Social Security arena, please do let us know and contact us. Yvonne Esparza, who's on this call with us, is a great person to be able to contact if you're looking to take any cases related to this matter. And for those of you who already do, thank you. We appreciate you. We cannot say thank you enough. So with that, I'm going to get started and turning it over to Kyle. Kyle Brenton is an active member of the MVL Advisory Board, and we are so thrilled that he's here to help us with this. Thank you all and enjoy.
Thanks, Tony Ann, and thanks everyone for being here today. It's a real pleasure to see so many people interested in an area of law that is so crucially important for the people who need it, and yet one that I think a lot of lawyers just don't encounter that often. We are really very, very fortunate to have with us today a panel of 3 absolute experts in this area who are going to walk us through everything an MVL volunteer would need or want to know to help us handle one of these cases. Our speakers today, our first speaker is going to be Mona Ahmed. And Mona is the Regional Chief Counsel for the Social Security Administration in Denver. Her office handles thousands of these cases before the ALJs and in federal court. Mona has been with the Social Security Administration for 25 years in different regions. She's served a stint as an administrative law judge for SSA before she entered her current role as Regional Chief Counsel. She is a graduate of Case Western Reserve University and University of Illinois College of Law. Our second speaker is Rhonda Povich. Now, Rhonda is a practitioner who represents claimants in Social Security, SSI and SSDI appeals. She has her BA in Spanish and political science and is a graduate of Concord Law School and practiced in immigration first, but ended up taking some Social Security hearings and found that it was an area that suited her and now has a practice that is dedicated to Social Security representations. And I should add that Rhonda is absolutely one of our rock star MVL volunteers. She handles a tremendous number of SSA cases for MVL, also volunteers at the Denver Indian Center and in other areas. So we're very lucky to have Rhonda with the organization and here today. Our third speaker is Judge Scott Kidd. Judge Kidd is the Regional Chief Administrative Law Judge for the Social Security Administration over Regions 8 and 10, which is the regions out of Seattle and Denver. That means that he heads the group of judges who decide cases from the Dakotas, Utah, Colorado, Montana, Idaho, Wyoming, Washington, Oregon, and Alaska. So obviously that's a very large volume of cases. Judge Kidd has been with the Social Security Administration as an ALJ since 2010 in a variety of different offices, but has been the regional chief ALJ for our region since July of 2019. So we're really fortunate to have Judge Kidd here with us. Just a quick orientation of what we're going to cover today and who's going to cover it, and then I'll turn it over to our presenters. First, Mona will be presenting on the law of SSI and SSDI appeals. And that'll be about 30 minutes. And then Rhonda will be presenting on procedure and what you need to know to actually litigate one of these on behalf of an MVL client. And then Judge Kidd will be talking about the hearing itself, what you need to know about a hearing, and I'm sure giving us some great insight from the judge's point of view, which is something we're always looking for. And then we'll have some time for questions at the end. So thank you again so much for being here. Thank you to our panelists for giving their time. And I will now turn it over to Mona.
Kyle mentioned that my office handles thousands of these cases, and we handle cases at the court level. And what we're going to be talking about today are cases that are at the agency level. One thing that's great about cases at the agency level is that the process is non-adversarial at that level. And so I think it's a great opportunity for volunteer lawyers to to be representing in that context. There's nobody at the Social Security Administration who's like representing the government or trying to argue a position that the claimant shouldn't get benefits. Our goal, our mission is just to get to the right decision, get the right outcome, and to do it as promptly and efficiently as possible. So I was going to talk about that at the end, but I thought it would be a good place to start. Okay, this is just a quick overview of what I'm planning to cover in part one of today's presentation. I've got three main topics. I'm going to give you a very quick intro into our two main benefit programs. Then we're going to spend most of our time talking about how SSA evaluates disability, what that analysis looks like. And then we'll end with a very short handful of practical notes. I thought I'd mention a quick note here about acronyms. I'm going to try not to use them unless I've already explained what it is. We do have lots of them in our specialized area of the law. So if I slip and you don't know what I'm talking about, please throw a note in the chat to remind me to explain an acronym. We're going to just scratch the surface of SSA law here, but I think you're going to have a good overview and certainly will be sufficient to help you dive in and handle some of these cases. Know kind of what to spot and when you'll need to look into something a little bit further. So on this slide here, you see a bit about our two cash benefit programs that SSA administers. There's some similarities between these two programs, but there's also some really important differences. So I want to quickly review them to help highlight those differences so that you know what to look out for. The first program is Title II. It's contained in Title II of the Social Security Act, so we call it Title II. You'll also see it referred to as OASDI, and that reflects that there's sort of three types of benefits in this program. There's old age insurance benefits, survivors insurance benefits, and disability insurance benefits. The old age is what you may know as the retirement program, somewhat of a kinder moniker, I guess. But that's Title II. And again, today we're going to talk mostly about the disability program, but just know that retirement and survivors insurance is also available under Title II. And then we have the Title XVI program, or the SSI program, Supplemental Security Income. And again, Supplemental Security Income can be based on age, based on blindness, or based on disability. Today, we'll talk about disability. So taking a bit of a closer look, the key in Title II cases is that this is an insurance program. So Title II provides monthly benefits to qualifying individuals who have worked long enough and they've worked recently enough and they've paid Social Security taxes on their earnings. So you have to have worked to become insured. By contrast, Title XVI is a needs-based program. So there's no insurance requirement, but to qualify, individuals have to meet the Act's criteria for income and resource reflecting their need. It is possible to have worked and be insured under Title II, and yet also still meet the Title 16 needs criteria. So we call these concurrent cases, where somebody is applying and may qualify for both Title II and Title 16. A couple additional notes about Title II disability. We also call this DIB, D-I-B. For those who qualify, payments are based, the amount of your payment is based on your earnings. So there's a formula that determines the amount of your monthly benefit. And those who qualify can also get Medicare. In most cases, it's 2 years before that entitlement kicks in. There's also a concept in DIB called a period of disability that just refers to a continuous period of time during which an individual is disabled. Excuse me. You'll see that term and you might want to know what it means. It has a specialized, there's a context in which it might really matter. You're very unlikely to see those cases, so we're not going to get into it today, but you will see that term, so that's what it means. And then just know that there are some other types of benefits under Title II that might involve a disability determination, and those are reflected in the third bullet there. I'm not really going to spend any time on this slide. I just wanted to include it in case you need it down the line, so it'll be in your materials. These are the basic entitlement factors for disability insurance benefits, DIB. Well, one of those factors on the last slide, it is worth spending a bit of time on, and that is what we call insured status, or the date last insured. So the claimant has to prove that they became disabled while they were insured for disability purposes. And that was, I talked about, you have to have worked long enough and worked recently enough to qualify under Title II. So SSA is going to calculate this date last insured, and in many cases, it's going to be sometime in the future. And if it's in the future, it's just going to be in the background. You're not going to need to think very much about it. If the date last insured is in the past, then do pay careful attention to it. And remember that disability has to begin on or before that date. So that's the period that's going to be at issue in your case. That insured status requirement is only for Title II. So in Title 16 cases, there's no equivalent. But again, Title 16 is a needs-based program. So individuals will have to meet certain income and resource requirements. And unlike in Title II, where the amount of benefits was based on earnings, here the amount of benefit is fixed generally. There's a maximum amount in 2022. Right now, the maximum amount is $841 a month. That gets adjusted down sometimes if a person has countable income. Again, SSI is providing cash assistance to the aged, blind, or disabled. One thing to know is that for adults, the disability analysis is the same in both Title II and Title 16. Title 16 does have benefits. Individuals can qualify for benefits if they're under age 18 and if they're disabled. And the disability analysis for under age 18 is different. So that's something to look out for should you be representing a child in a Title 16 case. Again, I'm not going to spend much time on these eligibility factors, just know they're there for reference. And here, these are the key differences between Title II and Title 16. I think we've hit most of these. Couple that we didn't hit, in Title II, you can get up to 12 months of retroactive benefits. Title 16 benefits, they're payable, only starting with the month in which the application was made. DIB actually involves a waiting period, a 5-month waiting period. There's no similar requirement for SSI. DIB requires insured status, SSI doesn't. SSI has income and resource limits, DIB doesn't. DIB leads to eligibility for Medicare. SSI does not, although in most states, if you're eligible for SSI, you're also eligible for Medicaid. I'm pretty sure Colorado is one of those states, but hoping Rhonda can correct me if I'm wrong about that. And those are the key differences. Okay, so let's move into what disability means. And what you see here on the slide is the basic definition of disability that's in the Social Security Act. It's the inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, et cetera, et cetera. Like most statutes, this is a mouthful, many, many parts to this definition, and we'll break them down. You'll see they're broken down a bit in the regulations. And by the way, I have no citations on these slides, but citations will be in your materials. The Act continues to explain that disability requires a showing that there's a physical or mental, your physical or mental impairments are of such severity that a person can not only not do their past work, but also cannot do any other kind of work that exists in the national economy. So I think we're gonna simplify it a little bit, put it into lay terms. And this is broken down on the next slide. Disability for SSA purposes means a person can't do any kind of significant productive work. Got it. Perfect. Okay, they can't do any, I'm sorry, could we go back one? One more. Got it. Okay. So take that, that statutory definition, 2 very long paragraphs. I think we're trying to break it down into small parts. We're talking about the inability to do significant and productive work. It has to be due to a medically documented impairment. That can be a physical impairment, it could be a mental impairment, but those impairments are causing limitations that are affecting work. And that medically documented impairment is something that you'll see throughout SSA's rules, that's a requirement for any sorts of limitations or symptoms. And then there is that duration requirement, so short-term or minor health problems aren't going to qualify. Important to remember that our definition of disability for SSA purposes is very likely different from the definition for some other agency and other programs. A quick note about sort of burden of proof here. The Social Security Act says that it's the claimant's responsibility to prove their disability, provide us with what medical and other evidence that's required to establish disability. It's stated a little bit more directly in the regulations. We say you have to prove to us that you're blind or disabled. All right, so our regulations outline how agency adjudicators are going to decide whether an individual meets that definition of disability that's in the Act. And that is through a 5-step sequential evaluation process. So we use this process to evaluate adult claims. It's the same for both DIB and SSI. And the steps are followed in order. But as soon as we answer, if we can decide a person is disabled or is not disabled at any step, then the analysis will end. So sometimes we don't go through all 5 steps. The point of this is efficiency. If we can make a decision earlier in the process, it makes sense to do that. So these are the steps. We're going to talk a little bit about each one of these, but if you're wondering why there's 6 boxes here instead of 5, that's because there's an important in-between step. You see it there between step 3 and step 4. It's not really officially a step, but I like to break it out because it is an important part of the evaluation. Some people even call it step 3.5. Okay, so I'm going to start with step 1. The question at step 1 is to ask whether a person is currently performing substantial gainful activity. And the point of this step is to weed out any cases where a person is actually working. So if the answer is yes, then we're going to stop the sequential evaluation. Now, not all work activity is going to be considered substantial gainful activity or SGA. If the work is very part-time, if it's sporadic, if it's done with a lot of unusual accommodations, then it may not qualify as SGA. But if it involves significant and productive duties and it's done for pay, then a good chance it is SGA. And the most typical way we think about SGA is through monthly earnings. We have a monthly earnings threshold. For this year, that threshold is $13.50 per month. So someone who is earning that much on a regular basis, it's a good chance they're doing SGA. There are some exceptions to that. So, take a look at those exceptions if you are representing somebody who does happen to be working. So step 2 asks whether a person has a severe impairment. The point of this step is to weed out essentially groundless claims. These are cases where someone's impairments are so minimal, they don't really affect the ability to do work much at all. And in that case, we stop the sequential evaluation. If the person does have severe impairments, then we're going to move on. There's actually 2 parts to this inquiry. The first part asks whether an impairment is medically determinable. It's about the existence of an impairment. And the second part asks whether the impairment is severe. And that's related to the impact of the impairment. How does it affect functioning? So here you see what medically determinable means. Results from anatomical, physiological, or psychological abnormalities that can be shown by medically acceptable clinical and laboratory diagnostic techniques. Just a note that an impairment, there has to be something documented by medical evidence. We can't establish an impairment based on someone's statements about their symptoms standing alone. Severe, whether an impairment is severe, is looking at how it affects basic work activities. It's a bit of a term of art, it may sound a little bit different than how you would understand the word severe in its common usage. But we say, an impairment is severe if it significantly limits the ability to do basic work activities. Significantly limit means, it's more than minimal. It's not just a slight abnormality. This is not a very high standard to have an impairment that's severe, but it's also not a toothless standard. And basic work activities are outlined on the slide here. They can include physical activities. They also include capacities for seeing, hearing, speaking, use of the senses, how those come into play in work activity. And then mental activities, things like understanding instructions, using judgment, interacting with others in the workplace, dealing with change, and that sort of thing. Again, these are all important activities for most types of work. All right, step 3, does the claimant's impairments meet or equal the criteria of a listing? And so steps 1 and 2 were about weeding out claims where the person was working or didn't have much wrong with them medically. Step 3 is the opposite. Here we're looking to quickly decide cases where we can assume, based on medical evidence alone, that a person's condition precludes all work. So we do this through something called the listings. That's exactly what it sounds like. This is a list of medical impairments, a very long list. It's in Appendix 1 of our regulations, and it's organized by body system. And you'll see for each body system, there are types of impairments that are associated with that body system. And then there's specific medical findings or criteria. And if those criteria are present, and if any duration requirement is met for those criteria, then the person will be found disabled. An example of a listing level impairment would be chronic kidney disease that requires dialysis. If the dialysis has already lasted or is expected to last for 12 months, that person is disabled. That's listing 6.03. Okay, here's that in-between step we talked about, called residual functional capacity, or RFC. Again, this is an important step, so we'll spend a bit of time here. RFC is the most you can do despite your impairments. So it's really talking about kind of how do impairments affect your ability to do work type activities. And a good way to start thinking about RFC is to just take a look at an example. This is an RFC finding that you might see in a decision, and it sort of outlines what the person can still do. They can still lift 20 pounds. They can 20 pounds occasionally, 10 pounds frequently. They can stand and walk for 6 hours. They can sit for 2 hours. They have some limits on reaching, but they can occasionally reach and handle. Some environmental conditions that are appropriate for this person. They should not be exposed to extreme temperatures. and they can perform only simple routine tasks. So as you saw in that example, RFC is typically expressed in terms of abilities, or it's expressed in terms of limitations. And we're assessing how a person's impairments affect these kinds of functions. Well, first, we're gonna think about physical activities. And when we think about physical activities, for SSA purposes, we put them into two categories. We think about exertional activities and non-exertional activities. Exertion just means it requires strength. So things like sitting, standing, walking, pushing, pulling, lifting, carrying. Activities that don't require strength, or at least not very much strength, we call those non-exertional. So you see on that last slide, there were physical activities that fall in the non-exertional category. There's also mental activities and other, those sensory activities, environmental conditions. Those are all going to be non-exertional, and all things we're going to think about in terms of how someone's impairment affects their ability to work. A few key points about RFC. We assess it based on what someone can do on a regular and continuing basis. That means 5 days a week, 8 hours a day. We're going to consider all medically determinable impairments in combination. And we're going to base it on all relevant medical and other evidence. So these concepts can get a little bit complicated depending on the facts. So one thing, as an example, you'll see in our regulations, there's 5 different categories of evidence. I think, the bottom line for you to think about as you're diving into your first case, we're going to consider all evidence. A few things that are important about RFC is that, we do have special rules for evaluating certain types of evidence. So it'll be important to spend a bit of time getting familiar with those rules when you get a case. So medical opinions. We have special rules for evaluating medical opinions, and the key factors in our analysis there are going to be supportability. How well is an opinion explained? How well is it supported by objective medical evidence? And then we're also going to look at consistency in that context. How consistent is the opinion with the overall record? We also have special rules for evaluating subjective symptoms. The classic subjective symptom is pain, but there's many other types of symptoms that are related to medical impairments, things like fatigue, trouble concentrating. The key here is that there must be a medically determinable impairment that is reasonably expected to cause the symptom. And then if you've made that initial showing, then we're going to consider a variety of different factors and a lot of different evidence about that symptom to assess how it affects work. If you have arthritis in your knees, we're going to reasonably expect that there's pain in the knee. So it's not a high standard to meet that requirement, but it is required that the symptom is related to a medically determinable impairment. And then finally, you want to know that we have special rules for evaluating mental impairments. And I think the key here is that at steps 2 and at steps 3, we're going to think about mental impairments in terms of pretty broad categories of functioning. When we get to the RFC stage, the assessment is going to be more specific and more detailed in terms of being expressed in work-related terms. Okay, we're at step 4. Step 4 asks, given the RFC that has been assessed, is the claimant able to do past relevant work? Again, we might stop at this step. If the person can do past relevant work, they will be found not disabled. The analysis ends. Well, what is past relevant work? It's mostly just like it sounds, work someone has done in the past. But we do take into account some restrictions on that. We're only going to look at whether work was performed in the last 15 years. And we're only going to consider work to be relevant if it lasted long enough for somebody to learn how to do it. And we're only going to consider the work to be relevant if it was done at the level of substantial gainful activity sort of linking back to that concept that we talked about in step 1. Step 5, the last and final step, if we've gotten here. The question is whether the claimant can perform any other work existing in significant numbers in the national economy. If the answer is yes, then the claimant's not disabled. If the answer is no, the claimant is disabled. Again, we're going to make this determination considering the claimant's RFC, that RFC that we assessed earlier in the process. We're also going to consider the claimant's age, education, and work experience at step 5. Remember earlier I said it's the claimant's burden to prove they're disabled. There's a limited shift in that burden at step 5 in that the agency has to show there's some other work the claimant can perform. Wouldn't really be fair to require a claimant to rule out the possibility of any kind of work in the whole world that they could do. It does make sense to ask the agency to show there is some work a person can do. There's a couple of ways that the agency adjudicators are going to think about that showing of either the existence or the non-existence of work. So the first way that we are going to think about showing the existence or non-existence of work is through what we call the medical vocational guidelines, also known as the grid. Call it the grid because it kind of looks like a grid. Got a sample page on the slide there. And where a person's RFC, age, education, and work experience all match one of these rules that's outlined in the grid, then that rule is going to tell us this person is disabled or not disabled. So if you looked at the first line here, rule 201.01, we see this is a rule for a person who's of advanced age, and our regulations are going to define what that means. They have a limited or less education. Their past work experience has been unskilled, or they have no past work experience. With that profile of vocational background and an RFC that's limited to sedentary work, the grid tells us that person is disabled. We're only going to use the grid if somebody has exertional limitations only, for the most part. As you saw when we talked about the types of non-exertional limitations that are out there, there are many. So there's a lot of cases where we may use a vocational expert instead of relying on the grid. But the grid is always going to be kind of a starting point for how we think about the step 5 analysis. And that's because somebody might have non-exertional limitations that mean they can do less than what's contemplated in the grid. So if somebody had the exertional abilities to do sedentary work, but they also had some non-exertional limitations in addition to that, well, that sedentary grid is still going to be a good starting point and will tell us if it tells us that person is disabled, if they could do all sedentary work, well, then they would still be disabled if they can do less than all sedentary work. But in many cases at step 5, we will see involvement of a vocational expert to assist our adjudicators with that analysis. Last point about step 5 to note is that employability sorts of factors are something that we don't consider. These are things like whether a person would be hired for a job, what are the kind of economic conditions in the local area, hiring practices and things like that. So that is the sequential evaluation in a nutshell. This is just a quick recap. Might be helpful for reference, but I don't want to spend any time on it since we're getting close to the end here, and I want you to hear from Rhonda and Judge Kidd. A few practical notes here. If you could go back for just a second. Kind of sources of law, and what in your materials you'll see, I think key provisions of the Social Security Act and regulations that you'll find most useful. Just a quick note about the regulations are found in Title 20 of the Code of Federal Regulations. The Title 2 regulations are in Part 404. Title 16 regulations are in Part 416. And then for the disability analysis, Title II regulations are in subpart P, that starts with a 0.15, and the Title 16 regulations are in subpart I, so they start with a 416.9. So if you were looking at the regulations are essentially identical for Title II and Title 16, but they're not going to match up in terms of what the numbers look like. So if you're looking at 20 CFR 404-1520, that's where the sequential evaluation is found. That's going to be identical to 20 CFR 416-920. Once you kind of get those numbers in your head, it's a little bit easier to keep the regulations straight. You'll see we also have a number of sub-regulatory policy guidance rulings, Social Security rulings, and then we have some acquiescence rulings. Those are based on court decisions. So when a court issues a decision that conflicts with our policy, we issue an acquiescence ruling. Otherwise, we have a national program. Our adjudicators follow the act, the regulations, and our rulings. But if there's an acquiescence ruling, it would apply in the circuit affected by that court decision. Lucky for you, in the 10th Circuit in Colorado, there's only one acquiescence ruling, and it's not on a disability topic, so you're likely to never encounter it. Lastly, there are just some operating instructions that may be useful if you're looking at procedural issues. This list here is just some things to be aware of that can get quite complex. So I'm not going to spend time on them, but I would recommend if you encounter a case where you think reopening is an issue, or it's a Title 16 case with a child under age 18, and there's one of those different analyses. Also, continuing disability reviews. These are cases where someone's been getting benefits and they're going through a process where the benefits might be terminated, or cases involving drug abuse or alcoholism. Special rules for all of these. It might be good to get a mentor or connect with a more experienced practitioner to give you some background on these. Final point I wanted to make is just to be sure everyone is aware that representatives must be familiar with and follow SSA's rules of conduct and standards of responsibility for representatives. So those are set forth in the regulations. And again, the sites are in your materials. They're just, I don't think you'll find anything too surprising in our rules of conduct. They reflect that, you're an advocate, an agent, and a fiduciary of the claimants. You need to follow our rules. You need to provide competent assistance. You need to, make sure that you're helping the process be efficient. There's a list of prohibited activities, again, that won't be at all surprising. Just important background for you to have as you start representing claimants before the agency. Final note, I started here and I'll end here again. Our proceedings at the agency level are non-adversarial. So again, our goal and our mission is to get to the right outcome and to get there as efficiently as we can. I think it's a good, kind of related to our standards of conduct and the non-adversarial proceedings. We have hundreds of thousands of cases that are awaiting a hearing in our process. And so, efficiency does matter. And I think, the more kind of familiar you are with that and sort of understand that it's a good background to have in the back of your mind as you start approaching these cases. Thanks very much. And I'm going to turn it over to Rhonda.
Thank you, Mona. Before I get into the procedural stuff, I wanted just to add a couple of things before I forget. When Mona was talking about proving or the burden to prove that an impairment is severe, something that is also considered is whether or not the claimant needs accommodations at work. So maybe they can do a lot of things like they could before, but now they need oxygen 24/7, or, there's a million examples, or they need a walker when ambulating. So those things are also considered when we're talking about if an impairment is severe. And then another thing I just wanted to add, because the Title II and Title 16 rules and, all the nuances involved with both of those, I don't want to say it doesn't matter. Of course it matters. But when you get a claimant in front of you that needs you, at that point, mostly we're just talking about helping them deal with showing and meeting that burden that they are disabled. So it kind of doesn't matter other than some date last insured rules and things like that. If we completely understand the nuances between those two, because at this point, we're just helping them to, show what they can't do and prove what they can't do at work and why they can't work anymore. So don't get too overwhelmed by the differences in those approaches to disability. And then one other thing is sometimes I've had a lot of attorneys come to me and think they didn't have a claim anymore, or that the claim has died because the person has gone back to work. So I did also want to say that when Mona was talking about SGA and work that's substantial gainful activity, a person might be able to go back to work at some point. That doesn't mean their claim is dead. We can change it to what's called a closed period. So if somebody has been out of work for at least a year, it's great that they went back to work. That means they're doing better, but don't be discouraged and think that that claim, is something that we still can't argue for the claimant. I just wanted to add those things. Thank you, Mona, and thank you, Kyle, for the intro. So what I'm talking about now in my little section is the role of the attorney representative in the procedure. So basically what we do and the order in which we do it when we meet a claimant that needs our help. So for an overview, I'm going to talk about entering a claim. So when we enter, what we need, when we're doing that, what information we need, the order of the claim process itself, kind of the order of that the claimant will go through, but we may encounter new claimants at any point in this order. And then what to do when we're preparing for a hearing, when we get to that part of the order. And then just some generalities when it comes to MVL clients and just some of the problems and issues that you might encounter. Because whether it's MVL or not, I'll just say now a lot of people with mental illness, there's some extra tricks maybe that I've learned along the way that are really helpful when communicating. Okay, so to start out with, entering a claim. So an attorney representative can enter a claim pretty much at any time. Even before the person applies, you could theoretically enter as their attorney rep as they're applying. I don't think I've ever done this though. Most of the time, whether it be through MVL or even just out, in the world, by the time you enter a claim, it's because somebody has come to you, they've already applied, they've been denied at some level, or, they've been denied more than once. But I just want to throw it out there that we can, and I'll get into that, but we can enter anywhere. So there's the application stage, there's the reconsideration level, which by the way, everybody calls everything an appeal. So that's the appeal level 1, the request for a hearing level, which everyone also calls an appeal. That's kind of the appeal level 2. Then there's the hearing, which means we requested a hearing and now it's scheduled. And then if your hearing is denied, then there's another appeal that you can ask for that to be reviewed. And then there's even the highest level, which is the federal appeal level, which I'll add now. I may repeat it later, but that's not something you're going to get too much of through MVL. I think I've had 2 at that level. And then, of course, as Mona mentioned, you will get claimants that already are or were receiving disability and they're facing termination. I'll talk about that a little bit later. And I want to mention now that a lot of times you'll get a claimant that already had an attorney on their claim. Maybe the attorney dropped off or the claimant didn't realize that their relationship has been terminated with that attorney, or sometimes they just want a new attorney, just like all areas of law. So we'll talk about that later, but it kind of doesn't change much. There's just a little, you just have to have that attorney withdraw. So the basic, at whatever stage you're entering, does not matter at all. There's basic information that you absolutely need. And it seems obvious, but you need the full name. If it's a minor, then you need the name of their parent or their legal guardian. The social security number, obviously, date of birth, phone number. And I add here that with homeless, a lot of claimants through MBL and just in general are homeless. So backup phone numbers are really important, caseworker phone numbers, and then email, optional, but a lot of homeless people actually have consistent ability to check their email, but maybe not a consistent ability to have, maybe their minutes run out on their phone or something. A mailing address, and mailing is in bold there because, again, a lot of people are homeless or indigent or change addresses a lot as far as where they live. But most everyone has some kind of mailing address, post office box, or again, like the homeless shelter or something like that. And then the last three, mother's maiden name, city and state of birth, and father's first name, seem odd. It's like asking for everyone's, the most personal information that you would need to, steal their identity, basically. So sometimes people get a little freaked out when you ask them all these questions. But at some point, you will need those last three, because if you ever have to call on behalf of the claimant or for yourself, or have a paralegal call and check the status of something, which happens all the time, they will ask you these questions to make sure that you're not someone trying to commit fraud. So again, no matter where you enter the claim, you will need these forms. And this will be repeated throughout, but the 1696 is essentially the entry of appearance for these. It's not what they call it, but that's what it is. It's needed no matter what. You need that. It's the claimant agreeing to allow you access to their social security file and to represent them and to speak on their behalf. The 827, I enter it every time. Some attorneys don't, and then they get a call that they need it later. So you should just enter it right away. This is the claimant's signature that is authorizing the Social Security Administration to request their medical records. It's sort of like a HIPAA release, not exactly the same, but it serves the same purpose. And if your claim lasts long enough, sometimes they stretch out over 2-3 years, you'll need to send updated 827s along the way. The next one is a fee agreement. There is an official, by the way, the 1696 and the 827 you can find on I have the website at the bottom there. You can get those forms. The fee agreement, there's also a form on the SSA website, but most law firms use their own. I have, by the way, after the class, you guys should get a PDF. I have copies of all these forms that I use, including my own fee agreement. Right now, we won't touch on everything that the fee agreement needs to include, but right now the fee agreement states if you are doing this as a volunteer, then you would waive the fee, obviously, but just for the sake of understanding, a fee agreement, if you're not doing this as a volunteer and you are actually taking a claim, you are allowed by statute to get $6,000 of the claimant's back pay or 25%, whichever is less. And I believe I saw a question pop up on the screen. That is changing, I believe. I think it has changed. I don't know when it goes into effect, but I think it's now gone up to 7,500 or 25%. The other form is called the 3441. You do not necessarily need this right away to enter, but you will definitely need it at the reconsideration level and again at the hearing level. So it's just a good form to at least have completed. This is actually a questionnaire. I think it's 8 pages long that you'll want the claimant to fill out, whether you enter it now or later. Okay, I already talked about this, but the basic order of the procedural order for this process is the application, and that would be the, either the SSI or the SSDI application, or both. The request for reconsideration or appeal level 1, request for hearing or appeal level 2, the hearing itself, and then after, which I discussed. There's several different things that could happen after. So let's talk about the application stage. So something that happens with MVL and the indigent claimants is when a claimant gets a hold of you and wants you to help them, I would say at least 50% of the time, they have no idea if they have an SSI or an SSDI application. They all say they have a disability claim. It's not a big deal. Like I said, most of the time when they come to you, they've already applied. So it is what it is. You still enter the claim. And this is, if you're entering with them, then you will help them figure it out. But like I said, most of the time they've already applied. They might call you and say, I applied, I'm waiting on my decision. Just enter your 6096 and 827 and fee agreement. And once you are entered as the attorney, you can call, it takes a few weeks, but you can call and ask, hey, what kind of claim is this? So that's not that big of a deal, but people just don't know what they have most of the time. When someone is asking your advice and they haven't applied yet, I don't know if Judge Kidd and Mona are gonna disagree with me on this, but in my experience, claimants, especially mentally ill claimants, have an extremely difficult, if not impossible, time applying on the internet. It just, something goes missing. It's really hard to apply for SSI on the internet for some reason. SSDI is easy. Something gets left out, or they don't have computer access. So I advise people, I would say 90% of the time, to call their local Social Security office and ask for an appointment to apply. I tell them to ask for an in-person appointment or a telephone appointment. Obviously, those are changing on how they do that because of COVID and coming out of COVID. There's a couple of reasons why, like I already mentioned, one, people just have a difficult time if they don't have access to the computer. But also, if they talk to a person at the office, then we know that the I's are dotted and the T's are crossed with the initial application. It's just the easiest thing. It takes patience because you might have to wait on hold and get an appointment, but it's just what I tell people to do. I sometimes will send people the paper applications, which SSA doesn't like to tell people that they can even do that. And I have included those in the PDFs as well. You can just send them the SSA 16 or the SSA 8001. They will fill them out, get them back to you, and you can fax them for them. That's another way of doing it. But that's usually when I get a claimant, they've already applied. They don't have to really worry about this too much. And then the next stage, like I said, at the application stage, you can enter the same forms that I explained. You don't need a 3441 at this time, just those first 3 forms. And really, the only role for us at this point is to facilitate the process, make sure the application's in, make sure they get their appointment. Let them know that once they've applied, it could take a year. You're going to read other things. I'm coming up on almost 4,000 hearings now, and I can tell you I have some people that have waited 2 years for a decision. So I just tell people they might be waiting for a year. They're going to be getting forms and questionnaires along the way. So I just kind of give people a heads up. Cool, now we're waiting. And anything you get in the mail, fill it out. If you need help, let me know. That's really our only role at this point, is just to kind of help them wait. Now, at some point, they will be denied. I have had one claimant ever that I have, and like I told you, I've had almost 4,000 hearings. I've had one claimant get approved at initial application. So they will get denied, and then they have 60 days to appeal that, which is actually called the request for reconsideration. This is also where I get most of my claimants. They get that denial letter, then they call me. They're like, oh my gosh, what do I do? So this is probably going to be the bulk of where you get your claimants. Same thing, you find out they've been denied. You send in the next page, we don't go there yet, but we'll send in those forms. Something that also scares attorneys sometimes here is a homeless claimant won't get their mail all the time. I mean, they might only check their mail once every 2 months. So they get this denial and that 60 days has already passed. Oh my gosh, they're panicking. It's okay. Many times, they find you, you enter, and you will include a late but timely letter. I don't know if I included one, but I will give my email at the end. I will be glad to share the letter that I use. It's a letter of good cause. It just, there's a million reasons, but most of the time it's like, hey, I got denied, claimant got denied. They couldn't find an attorney. They didn't know what to do. They finally found me. We're taking care of this immediately. I've never had one be turned down. I even had a guy that was about 9 months late, but I mean, it was COVID and he's mentally ill. And I mean, come on. So as long as you include that letter and give a good reason, they usually will allow that late submission. You can, I fax everything because I can get a fax confirmation, obviously, but at this level of appeal, you can drop it off at the Social Security office, you can mail it, or you can fax it. By the way, when you go to the ssa.gov website, you can go to forms and there's a little icon that says local Social Security office. If you enter the claimant's zip code for their mailing address, it will tell you who where their local office is. And that's where you want to always send everything. And by the way, claimants will never know, for the most part, where their local office is. Even if they already applied, they won't remember where. So here at the reconsideration stage, same forms. The 1696-827 fee agreement, if you haven't already entered. But either way, even if they're already your claimant, the form you use is the SSA 561U2. It just says, hey, we don't agree and we want this to be reconsidered. Again, our role here as attorneys is to help facilitate the process. And this also, once they have requested reconsideration, lately it's been taking 6 to 9 months to get an answer, but it could take up to a year again to get a decision here. And I've had maybe 25 or 30 claimants get approved at this stage. It's pretty rare. So again, just you're helping them wait, you're waiting with them. There's something that could happen at this stage too, that the agency may request, if there's a lack of medical records or kind of a gap somewhere, that the claimant attend a consultative exam, either mental or physical, or sometimes it's a specialist vision to help supplement the record if the agency feels like they want more proof of disability or a certain condition. So that could happen here. Then at some point they will get denied. And now you do what everyone says again is an appeal, the second level appeal, which is requesting a hearing. Same thing. If it's late, I will get a lot of claimants here too. And if it's late, okay, you enter, you include your letter of good cause, why they were late 60 days. Same exact thing, you can just submit that to their local hearing office. The next slide is the forms again. Always those 3 forms when you're entering here. But if you were already entered, you're going to use the HA 501U5, which is just, hey, we disagree. We want to sit in front of a judge now. We want the judge to hear our testimony, and we want a chance to argue our case and explain why we are in fact disabled. The claimant is disabled. Again, they could receive requests for consultative exam. Also, I want to mention that the attorney can request, you can send a letter to the judge and say, hey, I would really like this claimant to go to this consultative exam. They have this new thing going on, they haven't been treated. And this is happening to me a lot more now because claimants had gaps in their medical treatment during COVID, where they just did maybe a lot of virtual appointments where, they couldn't really address maybe the tremors in their legs or something like that. So you can request a consultative exam too. Now, again, once you request a hearing, it'll be 6 to 9 months at least before you get that hearing scheduled. And when you get that hearing scheduled, the notice has to be at least 75 days in advance. So I mean, think about that. If you get a hearing notice in 9 months, then you add another 75 days to that. We're coming up on a year again. So this is not a speedy thing. Hearing stage. So you've requested your hearing. You now get the hearing date in the mail. Cool. Obviously you let your claimant know. Oh, and I want to add too that with mentally ill claimants, I would say more than I've only practiced a few areas of law, but more than in any of them that I've practiced, family law, immigration, I really try to make an effort to let my claimant know. You'll get their mail. You get a copy of their mail. I will text them. I'll call them and because they might not get their mail, and say, hey, you got a hearing notice. Put this on the calendar. In this area of law, I don't make assumptions ever that the claimant is following along and knowing what's going on, especially if there is a mental impairment. So anyway, you get the hearing scheduled. Sometimes I'll get a claimant that already has a hearing scheduled. And if it's a ways out, that's fine. I'm all right with that. I only need, if I have about a month to get what I need, that's okay. But sometimes they'll call Colorado Legal Services and their hearing is, this Friday. Well, I can't even have access to their file by then. It's impossible. So you may have to postpone the hearing. And most of the time they agree with that. They want help. They understand you need to prepare. So the judges will always approve that as well. You'll just postpone it and you'll enter your appearance. And then it'll be a couple, 2-3 months down the road, you'll get that hearing notice. Same way that you're still dealing with the local office with all this stuff. I will add one thing to the hearing stage. If a hearing has already been scheduled and you are postponing it or adding anything to it, you will need to deal with the local hearing office, not the actual Social Security office. So Denver OHO or Colorado Springs OHO, if you're doing local, or find out where that hearing office is, because once the hearing is scheduled, the claim is transferred for purposes of process, the claim is transferred to the hearing office. So you lose time and possibly the correspondence won't even get into the file if you send hearing correspondence to the local office. Okay, so the same thing, same forms exactly. If they already have a hearing requested or set, you just enter those 3 forms. Then something I want to add. So here is when the hearing stage is when our role as attorney representatives really picks up, our workload really picks up. Up until this stage, really, like I said, you're just helping the claimant wait. You're encouraging them, taking time. Maybe you're, helping them to get organized. But once the hearing is scheduled, that's when you really, by this time, you'll have access to the records. You can go over with the claimant, hey, I see you've been to these doctors. Do you still go there? You have a conversation. You will need to update the records. A lot of times, they don't see anyone anymore. You already have those files, great. But if they have their, their primary care physician or, chemotherapy regularly or something, then this is when you will get organized and figure out what records you need to get and submit into the file. And I'll get into some of that in a little bit. But all records, you obviously your goal is to get all the records into the file, but many times at a hearing, the records just aren't all there. Kaiser takes forever, for example. And there's some rules that apply to that, which we'll get into. So preparing for the hearing, I already started to talk about this already. You request, you can familiarize yourself with the record, obviously anytime, but you're not, I do 50 hearings a month at least. I'm not going to remember everything. If I read it every time, I'm not going to remember. So I start familiarizing myself with the record once the hearing is scheduled. Medical records are school records, especially if it's a minor, third-party statements, medical source statements. These are just specific opinions that you can ask a doctor to give their opinion on what the claimant cannot do. I have given you guys in the PDFs, you should get some copies of the medical source statements that I use. Then as the hearing gets really close, you've gotten most of the records, you have an understanding. I write briefs for almost every case. I work for a lot of other law firms that don't ever write briefs. The benefit to a brief it's not the same as in other areas of law. It's really just to facilitate the judge and the attorney to support the disability. I mean, if you have a 2,000 pages of medical records, I mean, they're not all going to be completely relevant. Some of them are just checkups, or maybe they had strep throat. So I buzz through I've gotten to where I know what I'm looking for, but I buzz through the record, I read it, and I index it, pointing out, things that are, a surgery or the fact that they got prescribed a walker. And then I kind of point out some of these important things to the judge in my brief. I didn't include it in the PDFs, but if anyone wants a copy of, I can send anyone a copy of redacted briefs that I've done. And you're also going to touch on their past relevant work. Then at some point before the hearing, you will talk to the claimant and get them ready. I really just want to know how they're going to talk, because claimants either don't talk at all. They love to say they're fine. Hey, how are you doing since your back surgery? And literally in the hearing, they'll go, I'm fine. So part of the reason my number one goal in preparing a claimant for the hearing is to help them understand that we need to really let the judge know what's going on. Where is the struggle? What do you have a hard time doing the dishes? What can't you do? And also just to let them know kind of how the hearing is going to go, which of course the judge will touch on. And then you go to the hearing. Now, pre-COVID, the hearings were at hearing offices, other than in some circumstances. I had a lot of claimants on at the Pine Ridge Indian Reservation. And in the winter, they cannot get out of the reservation to go to Rapid City for a hearing. So in that case, we did a lot of telephone hearings, or not telephone, but video teleconference. And then COVID, everybody turned to telephone and video teleconference. And we'll let the judge touch on this, but right now I have hearings scheduled through September, and they're all still either video teleconference or telephone. So I don't know what the future holds for that. But that's kind of how it goes. And then after the hearing, you will complete the hearing, and it takes right now, I think I had a couple of fast decisions, but usually decisions are taking 2 to 3 months. So again, you're waiting. And you'll almost never get a claim from MDL that already had their decision. Although I did get a couple that they wanted to do a federal appeal. And I think that's a whole nother CLE, but you're pretty much never gonna get a claimant that's already had their hearing unless their hearing was postponed for them to find an attorney. And also if you do get a claimant that's like, hey, I got denied and I want to appeal, it's pretty difficult to assess like if they even have an appealable claim, because you can't see their file, you haven't seen the decision. So that's kind of a big thing to decide to take a claim and appeal it at this level, because you don't even know what happened. I think that's all I have. So termination claims. So somebody already received benefits and they got a letter that said, so sometimes cases will be reviewed by the agency. Maybe, like I said before, someone has a back surgery. Maybe it's been a while and, the prognosis was good. They were definitely out of work for a couple of years. Things were bad, but the prognosis was good that they should recover. So maybe the agency has decided that this person's probably recovered. And so they can prove that they're not recovered, that they still cannot work. MVL doesn't usually take these, because Colorado Legal Services doesn't they usually tell people that we can't match them with attorneys for these. But I take them, I just advise them on what to do. And that's, I I'd be glad to answer anyone's questions later or via email if they get somebody in this stage. But for the most part, you won't get claimants through MVL that are in the termination stage. I've talked about a lot of this, but generalities, and I'm speaking about claimants here. MVL referral claim types are pretty much always going to be at least Title 16 because those are income based. And in order to even qualify for help under Colorado Legal Services, they have to meet pretty much the same income requirements. So you're almost every claimant, if not all, are going to be Title 16, and some will also be Title 2. Again, though, once you get them, it kind of doesn't matter what they've applied for because you're helping them prove their disability either way. It doesn't matter. Issues, homelessness, I talked about this. You will lose touch with claimants. Their phone, they have temporary minutes through, a prepaid phone or a track phone. Usually they're pretty good though at calling you. Like a month later, you'll get a text, hey, Rhonda, this is my new number. They forget to tell you who they are, of course, and I have to say, who is this? But that's something that will happen a lot. Caseworkers I'll email caseworkers a lot and say, hey, have you heard from so-and-so? I need to talk to them. I have mailed letters and emails, but sometimes they just drop off and there's nothing you can do. I've had to go hunt people down before at the Stout Street shelter, but for the most part, they will get back to you. And I will say that texting is your #1 communication tool in this area of law, especially if you have a claimant that has schizophrenia or like a borderline personality disorder or something, paranoia. They do not want to answer their phone. They don't want to talk on their phone. They think somebody's listening. Also, they don't remember what you told them. So I will text all the time. Hey, your hearing date's coming up. Hey, I got a letter, call me. Texting is, it's hard from an office phone, but my cell phone is my office phone for these purposes because it's the only way I can reach my claimant. They will not call me back if I call them. So that's something you want to wrap your head around if you don't like texting. And then if they drop off, you can withdraw or just let the claim die. There's not a lot you can do if you can't find the claimant. So, and then one more thing, homeless claimants will not have their paperwork. They just won't. It's hard enough to keep track of your life at that point, and they're not going to have. You're going to have to help them navigate and figure out where they are. So it takes a lot of patience and a lot of compassion. But once you know that, it's smooth sailing. Thank you.
All right, thank you. We'll go ahead and jump in, and while we wait for the PowerPoint to be loaded, I will again just briefly reintroduce myself. I'm Judge Stag and the Regional Chief Administrative Law Judge for Region 8 and Region 10 out of the Denver and Seattle areas. So let me say good afternoon to all of you and tell you just how excited I am to be here today. I can't tell you how much I appreciate all of you taking the time to come here and listen to us and at least entertain the possibility of taking on some of the Social Security disability cases. I think that, it's important for us to establish a good working relationship with the local bar. And Rhonda, I think, touched upon some of this, but for an individual pursuing a claim of disability, the outcome of their case is of extreme importance to them. For many of them, it's the difference between having a place to live or being homeless, or having the funds and insurance to receive some much needed medical treatment. So from their perspective, these hearings can feel overwhelming to say the least. And having a qualified representative to guide them through the process is of the utmost importance. From the judge's perspective, your presence will also help ensure that the hearing is efficient and as productive as possible. These take time. Individuals are waiting a long time to get there. We want to make sure that we are able to accomplish everything we need to accomplish at the hearing and not, incur any undue delays beyond that. So I would certainly encourage all of you to go ahead, jump in and give it a try in terms of representing individuals and dipping your toe into the Social Security world. So what I was asked to speak on here today is just the hearing process, kind of what we do at our level. And there will be a little bit of overlap from the other two speakers, so I do apologize for that. I'll try to minimize it. But what I wanted to start out with is, just kind of briefly explaining who exactly we are. Social Security is an extremely large organization. It consists of several parts or components that provide a wide array of services throughout the entire Social Security network. I work for the Office of Hearing Operations, or OHO, and we do love our acronyms here, but we'll again try to limit those. But you will undoubtedly hear hearing operations, or OHO, used if you decide to take on any of these cases. OHO is responsible for holding hearings and issuing decisions for claims filed under Title II or Title XVI of the Social Security Act. Essentially, when someone is seeking disability benefits, we are the component that's going to conduct a hearing and issue a decision on that matter. OHO itself is divided up into 10 regions, and I know we've already talked a little bit about Region 8 here, which is based out of Denver, Region 10 based out of Seattle. But within each region are multiple hearing offices. So in the state of Colorado, there are two main hearing offices. There's the Denver Hearing Office, which has 10 ALJs in total. And we have another hearing office in Colorado Springs, which has 6 ALJs in total. There are also several satellite offices that are used on a very limited basis, but essentially we're going to do the majority of our hearings in downtown Denver are in Colorado Springs. The hearing offices not only consist, of course, of the administrative law judges that will be conducting the hearings, but managers, staff, decision writers, and really they're the heart and soul of what the Office of Hearing Operations does. Each hearing office is led by a hearing office director or a hearing office chief administrative law judge. I point that out to you because if you ever have any type of issue or need to speak to someone, undoubtedly you'll probably hear their names and be referred to them. So, and again, given our love of acronyms, the hearing office director, or HOD, is an individual that if you end up doing a fair number of these hearings, you'll probably become somewhat familiar with. So wanted you to be aware of just how our offices are constructed, at least to a small extent. Currently, OHO has 164 total hearing offices throughout the nation. We also have 5 national hearing centers that conduct video hearings. Right now, there are approximately 1,200 ALJs throughout the nation that render approximately 500,000 decisions a year. At one point in time, we were the largest judiciary group in the entire world. That was a few years ago. We were around 1,700 ALJs. I'm not sure if that's still accurate or not, but I bring this up and I point it out because it goes to something that Mona said when she was speaking earlier. We are constantly doing a balancing act to ensure that we not only afford everyone a fair and just hearing, but we also have a responsibility to process and move cases in a timely manner and a large volume of cases, as you can see. So it's a rather large operation and a lot of moving parts to it. And that is why I think one of the reasons rather that it's so important that we have representatives like you involved to help ensure things move forward as smooth as possible and there's no breakdown along the way. So how exactly you request a hearing, and again, I think this has kind of been covered, but I'm just going to stress, a couple of things here. Individuals file a claim at the local level, and that is a review that is done not in front of a judge. There's no hearing process. They'll render a decision, they'll review the evidence, make a finding, essentially determining someone's eligibility and a determination as to if they are disabled or not. That can be appealed to the request for reconsideration, And then if that's denied, you can file your request for hearing. As was previously stated, it needs to be in writing. It can be done online. It can be done at the local office with an interview. We try to accommodate, and again, as Rhonda said, a lot of times individuals are suffering from some type of impairment, often a mental impairment. So we really try to make this process as easy as we can. We still need something in writing, but we try to be flexible in ensuring that everyone's due process rights are being protected. There is a 60-day period. We give a 5-day mailing period. So really, you have about 65 days from the request of reconsideration denial to file your request for hearing. But again, that's where the flexibility comes in. If you encounter that situation and it's beyond the time frame, go ahead, send it in along with the statement of good cause. And especially during the pandemic, we really try to factor all that in because our ultimate goal is not to, catch someone on a technicality. We are really trying to get to the right decision in these cases and ensure that if someone qualifies and is indeed disabled, they receive the benefits that they are entitled to. So you'll find that at least in this way, we really try to be as flexible as possible and take someone's situation into full consideration and not just dismiss a claim because it was a day late. That's a difference you will find between us and a normal, say, trial court. And this is a non-adversarial process. So what that means is there's no one there representing the government or Social Security throughout this process. And we'll talk a little bit more about that, but that kind of goes to the heart of what I was saying, that, ultimately we're working towards finding what we think is the correct and proper resolution in the matter. Once the request for hearing is filed, then OHO does assume jurisdiction. The case is moved over into the appropriate office, and eventually it will be assigned randomly to one of the ALJs in that office. At the hearing, the claimant and the ALJ representative will all have the right to question any witnesses. We'll talk about those here shortly. The ALJ is going to look fully into the issues and accept as evidence any documents that may be submitted. Following the hearing, the ALJ is going to issue a decision. Again, that must be in writing as well, based upon a preponderance of the evidence presented in the case. Hearings before the ALJ, like I said, are non-adversarial, which is why I think, yet again, another reason why your presence is so vital to help ensure everything moves efficiently and properly. Manner of appearance is something I do want to take a few minutes and talk about because it's a bit tricky and it's really something important that I think everyone needs to understand. So pre-pandemic, so if we go back prior to March of 2020, claimants and representatives generally appeared at hearings in person or by video teleconferencing. Video teleconferencing was a situation in which the claimant and the representative would appear in a different Social Security office than the one the administrative law judge was at. The ALJ or administrative law judge would conduct the hearing with the Social Security Administration's video equipment. Oftentimes this was done simply to help maybe one office that might be overburdened and needed to shift some work, or it was also done in situations where people maybe live very remotely and couldn't drive, say, all the way into Denver, but perhaps could make it to a different Social Security facility that, even though we don't staff full time, might have the necessary equipment for them to go to, and say like Grand Junction, so they could appear by video in front of an ALJ located in Denver. In general, video teleconferencing hearings were approximately 1/3 of the hearings we would hold. The other 2/3 were essentially in person, conducted face-to-face. There were very few situations that were extraordinary circumstances, claimant, representative, they may have to appear by telephone. you would often see this individuals maybe who would be incarcerated at the time of the hearing. Obviously, in person was not an option, and the equipment for a video would not be available. But overall, the bulk of our hearings were done in person at the hearing office. Now, when COVID hit, COVID seems to have changed so many things and different levels, but for us, it had a pretty profound effect. During the COVID-19 pandemic, back in March of 2020, our offices closed to the public. We did that to ensure everyone's safety, and we switched over to a manner of appearance in which individuals essentially had to appear by telephone, and then shortly thereafter, online video option was created. We are in the process of resuming in-person hearings, and as well as the video teleconferencing hearings in our hearing offices. But this is right now very limited. It's being rolled out slowly to give us an opportunity to make sure our COVID-19 health and safety protocols are sufficient. We are aware that, again, individuals appearing in front of us are there because they suffer from medical impairments. So we want to make sure that their safety is being protected as much as possible. We started this resumption of in-person hearings about 2 months ago, but again, on a very small number of cases. We are slowly ramping it up. There will be more in-person hearings throughout the summer, in particular in July and August, as we evaluate how things are moving forward and slowly hope to return to a normal situation. In the meantime, online video hearings have kind of become our default. Online video hearings are different than the video teleconferencing hearings in that the online video hearings are conducted over the internet and individuals are not in Social Security space. So with an online video hearing, the claimant and the representative can participate from any location of their choosing, their home, an office. Really, we just ask that wherever they're at is safe and secure and private, so there won't be any interruption during the hearing. Otherwise, it's entirely up to the representative and the claimant where they're located. Currently, we do these hearings using Microsoft Teams, which many of you are probably familiar with. It's a third-party communication technology, very similar to Zoom, a little bit different, but the same general idea. So this is really kind of an exciting development for us. As you might imagine, the government doesn't necessarily move super fast with new technologies and breakthroughs, but because of the pandemic, we're forced to really look at alternatives, and we developed this and have implemented this, and it's been very successful, at least from our standpoint. And it's something that I think may have some long-term impact, especially when, perhaps my local bias kicking in here, but as we cover areas such as the Dakotas, Colorado, Alaska, so many of the individuals we're trying to serve are located in very remote areas. And this gives them another viable option in terms of having their hearing. They don't have to find a way to travel, in some cases, hundreds of miles. And, as long as they have a device that can connect to the internet, they can at least pursue that option for a hearing and not be limited to just a phone appearance as well. The manner of appearance, and something I do want to stress, this is voluntary. It is entirely at the discretion of you, the representative, and the claimant. You have to consent to the online video or to a telephone hearing. You would do this by submitting a COVID-19 remote hearing agreement form, which we send out to claimants and representatives, and it's also available online. So if this is something that you start doing in the very near future, you will undoubtedly see something along this lines, and it's important that you understand it so you can advise and explain these options best to the claimants. You can find more information online at our website at ssa.gov/appeals, and it'll kind of explain this as well. There's also a ssa.gov/coronavirus that has frequently asked questions section and links to these forms. But ultimately, what we want is just to make sure that everyone understands that there are options out there, that if someone can't travel, they now have the ability to still appear by video and they aren't restricted to a telephone. If they want and insist upon an in-person face-to-face, we are moving towards that. And again, as I stated, that's something that hopefully will be an option just as it was prior to March of 2020 in the very near future. So time will tell on that, but again, those are being rolled out and we are increasing those. So keep all that in mind, because depending upon when you're approached by a claimant, this is one of the first major things you're going to have to kind of help guide them through, is deciding the manner of appearance. The hearing format and hearing process. So you decided how you're going to appear. That's taken care of. You come to the hearing, what's going to happen, what should you expect? So regardless, whether it's by phone, by video, whatever it is, in general, our hearings kind of follow a relatively set pattern. Few things to keep in mind with that. We're going to make a verbatim audio recording of the entire hearing. We're obligated to do this. It's a legal requirement that we have to make this recording. That recording is the official recording. No other recording, regardless of the manner of appearance, can or should be made. And that's something that will be explained to you. But again, I want to stress that because it is a question that, as you can imagine, during phone and different types of video hearings does come up on a pretty regular basis. During the hearing itself, the ALJ will decide when the evidence will be presented, when the issues will be discussed. They're also going to ensure that the claimant and you, the representative, understand sort of the flow of the hearing and the specific issue. So to do that, we advise and most follow the pattern that you see up on the PowerPoint right now. So most are going to start and they're going to kick off with an introduction. The ALJs are going to introduce themselves to the claimant, and they're going to identify for the record those individuals that are present at the hearing, and they're going to explain why everyone is there. So oftentimes there are expert witnesses involved. We're going to break those down here shortly, but the ALJ at the onset is going to introduce them, give an overview to make sure that the claimant is comfortable and understands who and why everyone is there. Sometimes they are caught off guard by that, or if someone else is on the telephone or on the video. And we just want to make sure, again, that they understand everyone participating and everyone's role in the hearing. The hearing itself, and yeah, you can just leave this slide up for a few minutes. In addition to the ALJ, the claimant, and of course you, the representative, essentially all hearings are going to involve a hearing reporter or a hearing monitor. As you can guess, their job is to operate the equipment that's going to make a recording of the hearing. They don't participate in the hearing in any other way, but they will be introduced as well when we explain that the recording is being conducted. The medical expert, vocational expert, and any other lay witnesses will also be introduced and discussed at that point. Once everyone's kind of introduced, we'll move on to an opening statement. The judges need to cover a few things in their opening statement. As you can probably have guessed, they need to explain just the procedural history of the case, what the issues are. They may ask you if you'd be willing to waive the reading of the issues. Again, that's your discretion. If you do, that's great. If not, then the judge will kind of cover just to make sure everyone understands, is this a Title 16 case? Is this a Title II? When is the claimant alleging that they became disabled? So that, again, everyone knows exactly what we're focusing on during the hearing, and we're all in agreement at that point, and we're ready to move forward. Now, if a claimant is unrepresented, one of the obligations that an ALJ has is we need to explain to them their right to a representation. We'll cover how the fees work. We will go over the benefits of having a representative. And if a claimant has never received those rights before, then more often than not, what ends up happening is we end up continuing the hearing and giving them additional time to go out and to seek counsel. And I myself was a former representative before I became an ALJ, so I know that a lot of times this is also when claimants might come to you and they'll come in and they'll say, well, I've already met the judge and I've had a hearing. And you start thinking, whoa, wait a minute, what's going on? Sometimes this is what they mean. They mean that their hearing was scheduled, they went in, but all that really happened was the judge asked them to identify any missing records and confirm their address, and then gave them some additional time to go out and to seek representation. So keep that in mind if they come in and they tell you that. It's not necessarily a bad thing or reason to panic. That's probably more often than not what has occurred. Once we conduct the opening, of course, we have to administer an oath or an affirmation. Generally, the ALJ is going to take testimony from any witness at the hearing only after they've taken an oath or an affirmation. So that'll be done at the onset by all participants. Then we're going to move on and discuss the evidence. So the judge is going to admit into the record any evidence that they determine is material to the issues involved in the case. Evidence is material, of course, if it's relevant, involves, or is directly related to the issues before the ALJ. The ALJ may admit information in the record, even if it would not be admissible in court under standard rules of evidence. Again, non-adversarial hearing. So we're not concerned with things like hearsay or, any of those other standard issues that might come up in a more traditional trial court setting. If there's information, it's pertinent to the issue before us, we're going to want to see it, and we're going to want to bring it in and make it part of the record. So it goes back to what I think you've heard now from all of us. We really want to just make the correct decision in a case. So we don't expect claimants to be focused and knowledgeable of the various rules of evidence. We really just want the record complete to the best of everyone's ability, so we have everything there and are ready to make a final decision. Now, in terms of the evidence, Social Security does have an obligation here to assist as well. So it's important to understand that. If we're aware of evidence that exists, we're going to try to help you get it if necessary. So we want to develop the record. It should have been developed as the claimant has gone through the process, initially filing the request for reconsideration. But because of the timing involved, just as you heard previously, there can be a large gap of time before the actual hearing. So we really need and want to get those records in there, and we will assist if and when that becomes necessary. We still need to know the medical providers, and if a claimant is represented, we're going to ask that you've made efforts to obtain those records or have identified them. And that's part of the claimant's obligation, is to submit or inform us about all evidence known to the claimant that relates to their case, whether or not they're disabled, essentially. So if you can't get it though, or if there's a problem with it, that's when our obligation is going to kick in, and we're going to provide assistance. We'll write to the provider, we'll reach out, we'll try to do what we can in order to obtain that evidence. Again, with the ultimate goal of just ensuring anything that is pertinent is added in so we can make a full, fair determination in a case. For submission timeframe, generally the claimant and the representative must submit or inform us about evidence at least 5 days before the date of the scheduled hearing. So it can be tough because evidence does not always move at the same pace. As was mentioned, Kaiser, I think, is kind of notorious in the area for being very slow to give records up. Some places are excellent, some places it's like pulling teeth. So what we ask is, if you've made efforts to get it and you can't, at least let us know 5 days prior so we can start working on it. Sometimes some providers might be more receptive if they see that the letter or the request is coming in from a government agency, or they're used to seeing our request. Not always, but in general, you need to let us know 5 business days before the date of the hearing. If you don't let us know, or if it's missing, then that's something that the judge will discuss at the hearing. And that's a question that you will undoubtedly get very early on, is the file complete to the best of your knowledge? What's missing? A lot of representatives will send in something and add it to the file prior to the hearing, just stating, records from so-and-so are missing. We were unable to obtain them. Can you please assist? Or perhaps we just learned of them. So ultimately, though, we'll work with you on that to make a determination of what's missing, what's necessary, and how best to try to get it added in. You can add in the evidence yourself in a variety of ways. When we're, again, prior to COVID-19 and the office was open 5 days a week, some representatives would simply walk it in and hand us a stack of papers. Didn't happen a lot. We kind of moved away from that, but it is a possibility. A lot of representatives will submit evidence via fax. That way they have a confirmation that it was sent, and we will add it in. Some representatives, an increasing number of representatives, actually will sign up for our electronic file system, ERE, and they will submit it themselves electronically. They can scan it and send it to us that way. And again, if that's something of interest to you, you can register for electronic file access at ssa.gov//ERE/. I would encourage you to look into that if you find that you're doing, more than one or two of these cases. I think it's beneficial. You can have access, you can review a file as well, because what we've moved to is an all electronic world for the most part. There are some exceptions, a few cases still out there, but the overwhelming majority of our cases are handled purely electronic. We've moved away from paper, which I'm sure you can imagine when you start talking about issuing hundreds of thousands of dispositions a year and hundreds of thousands of hearings. It's really the only way we could move forward and sustain the pace necessary to try to keep up with demand. So everything is put into this electronic file, divided up into different sections, and kind of grouped together. And we can talk a little bit more about that if you have any questions. But as a representative, you have a right and the ability to see that electronic file prior to the hearing. In fact, it's something we will ensure at the hearing, make sure that you've had that or claimant has had that ability. And if you run into any issues with that, if you want to try to gain ERE access and you can't, please contact the local office. They will be more than happy to kind of walk you through the process, explain the best way to submit the evidence, what to do. We want to, again, we're not looking to hold anyone up here on a technicality. We don't want anything missed because of this. So I can tell you that our staff would be more than happy to answer any questions you have on that. So if you take a case, you run into any kind of issue with this, please just pick up the phone, give us a call, and someone on that staff will be more than happy to find the case, answer any questions you might have, and tell you, the next steps that you might need to follow to get that evidence to us. I'm going to point out also, just because it might seem a little odd to you, but when you walk in to the hearing room itself, you're going to see that the judge is going to kind of be buried behind some screens often. And that's because, again, everything's electronic. So our judges take notes for the most part. There are a few exceptions, but they take notes during the hearing electronically on their computer, access to the file, the records, everything's going to be there. So when you walk in, every judge is going to have multiple screens set up in front of them. When you take your seat, you're going to find that you too have access to a computer, and most reps bring in a laptop. If you don't have access or don't have one, computer access will be given to you to ensure, again, that you and the claimant also have the ability to review the file throughout the hearing in case there's any issues or problems or questions. Now, once we have admitted the evidence, so basically what's going to happen is the judge is going to ask if the file is complete, what's missing, you're going to talk about it. The judge is going to ask if you have any issues or problems with the evidence that's already contained in the file. Very rarely is there any issue. Again, rules of evidence don't really apply. So usually it's just a question of if it's complete or not. At that point, we're going to admit everything contained within the file into evidence, so it'll be officially labeled as such. We're then going to move on and really start the heart of the hearing and start taking oral testimony. Judges do vary on this, so I think it's fair to say that we all have our own kind of unique approach. Some judges ask the majority of the questions. Some judges like to ask the questions first. Sometimes the judge prefers if you start asking questions. But overall, the ALJ is going to kind of determine the subject and the scope of the testimony from the claimant and any witness, as well as how and when they're going to testify during the hearing. So for example, the ALJ may decide to use a question and answer method, or the ALJ may allow the claimant or the witness to kind of just make very broad, open statements on the record. So, and I see we have a few questions popping up, so we will get to those here as soon as the presentation is over, so please keep feeding them in. Everyone does have the opportunity to speak. Everyone's going to have the opportunity to make an oral argument and ask questions. And you're also going to find that in general, what the judges do when they're asking questions and as the hearing moves forward, if you recall back to what Mona was saying about the 5-step sequential evaluation process, that's really how the hearings tend to flow. So you're going to usually start off with questions regarding work activity, which relates to step 1 of the sequential evaluation. Is the claimant working? When did they last work? We need to maybe, depending upon the answers there, get more information about the job. But that information is going to go to step 1, or whether the claimant has any past relevant work, which comes into play at step 4, the sequential evaluation. From there, most ALJs will move into questions relating to the alleged symptoms, someone's limitation, their medical history, treatment history, and questions about daily activities. These things are going to help the ALJ determine whether the claimant has a severe impairment, as well as whether or not the impairment would meet or equal a listing. These questions are also going to help the ALJ kind of assess the claimant's overall RFC, or residual functioning capacity, what's relevant to step 4 and 5. As I stated, you have the right to question any witness as well as the claimant. You also will be given an opportunity to make a statement, whether it's at opening or at closing. That's something that might vary from ALJ to ALJ. Experts, I've kind of mentioned this a few times. So in general, most hearings, not all, but most are going to have at a minimum a vocational expert. A vocational expert is someone who's asked by Social Security to provide professional testimony, impartial expert testimony, if you will, about jobs that exist in the national economy. They're going to help the ALJ determine if the claimant can perform their past relevant work, which again goes to step 4. They will be presented with the residual functioning capacity, and they'll help answer how certain limitations may impact the existence of jobs just in general. We may also have medical experts at the hearing itself, physicians, mental health professionals, other medical professionals, again, there to provide impartial expert testimony about the conditions, whether or not they meet or equal a listing, and what limitations they would expect based upon the testimony and the file that an individual suffers from. Again, they'll be administered the oath and subject to questions from the ALJ, the claimant, and the representative. Once oral arguments have completed, we'll move on to the closing of the hearing. And I'm trying to kind of wrap things up here. I think we're getting low on time, but the ALJ is going to determine whether the claimant and representative have any additional evidence, and then the ALJ is going to advise the claimant and the representative that the hearing is coming to a close. A written decision will be made, setting forth the findings of facts, conclusion of law, and that they understand that a copy is going to be mailed rather to the claimant and to the claimant's representative for review. Typically, that will conclude the matter. Now, I would state that post-hearing, there are sometimes when the hearing has to be set aside and the decision needs to be delayed. Can't always render a decision shortly thereafter. The most common reason, and we can go on to the next slide, the most common reason is because additional evidence is needed. You know, people are constantly going to treatment. There may be a series of tests scheduled for a week after the hearing, perhaps surgery, and the judge wants to see the results of that test or that next visit, or we find that something is missing from the record and we need to obtain that additional information. Sometimes new things come up in the case, and there may be a request, as mentioned by Rhonda, where it's decided or requested that we send the claimant out for an additional exam. We may want to do interrogatories. If testimony of the hearing leaves unanswered questions, we may want to supplement the record with additional documentary evidence involving a medical expert. So we would send out written interrogatories. If we obtain additional evidence after the hearing from a source other than you or the claimant, we're going to give a copy of it to you. So if we send out interrogatories and we get a response back, we will give a copy to you. We'll give you a time to respond in writing, as well as to determine whether or not you would like to request a supplemental hearing. And the supplemental hearing is just that. If you ask for a supplemental hearing, we'll schedule it, we'll come back in, we'll review those new records, make sure everything's up to date, and see if anything happens to be missing. The decision itself, generally upon completion, we have everything we need. We're going to render a decision. It's going to be in writing. It's going to identify the claimant. It's going to identify the jurisdiction, procedural issue, the issues involved, who was at the hearing, who testified, and of course, the ultimate conclusion of the case. Decisions come in a couple of different varieties. You're going to get a fully favorable decision, which is, as the name would imply, gives or awards benefits exactly as requested by the claimant. You might get a partially favorable decision. The ALJ will decide some issues in the claimant's favor, but some issues not. For example, they may find that disability started at a later date. The claimant asserted that they were disabled as of the date in 2018, but the judge thinks the evidence was lacking and the person did not become disabled until 2019, for example. Or of course, an unfavorable decision. Those are really the three main categories for a typical disability claim. They'll be sent out to you, the claimant, and explain what would happen next. If it's an unfavorable decision, we'll explain what your options are at that point. Some best practices for you, and again, try to squeeze these in real quick here. Would always recommend that you review the best practices on our website, which is listed on the PowerPoint. Rules of conduct, standards of responsibility for representatives is also something that I would suggest. You should be familiar with those, follow the rules set forth in our regulations. They identify the affirmative duties of a representative, such as notifying or submitting evidence 5 days prior, or 5 business days rather, prior to the hearing. And in general, couple of things that I would just suggest. We always welcome a pre-hearing brief. It's not required, but more often than not, judges appreciate it if you decide to do it. And again, it's not required, but if you decide to do it, short and sweet. It does not need to be a long, detailed law review article. 1 page, half a page. I've seen some super great briefs that are just half a page long. You just point out the key things, your theory of the case, kind of walk through the sequential evaluation, 1, 2, 3, 4, 5. I think judges find that helpful. I think if you can cite to the key evidence in that brief, that's very helpful. Again, this job involves a lot of high volume work. So judges typically hold 5, 6, 7 hearings on a hearing day. They'll have maybe 2 hearing days a week. So it's pretty normal for judges to do anywhere between 10 and 15 hearings on an average week. Medical records for those cases can range from 50 pages to, I think the most I've ever had was about 12,000 pages. So there's a lot there, and anything you can do to simplify it for the judge to, draw their attention, focus on this. This is what's key. This is what is important. I think that's vital, and I think will go a long way in helping the judge make sure that we cover everything and really are focused on what we need to focus on. Similarly, witnesses, you can bring in lay witnesses. Sometimes people want their spouse to testify or a friend. That's well and good. The judge will walk you through that process. Usually the witness needs to wait outside, then we'll come in after we take the testimony of the claimant. For timing reasons, you may have the witness submit a handwritten statement or type statement that's signed. Again, rules of evidence don't apply. It doesn't need to be notarized. It doesn't have to be a formal affidavit. They can just type it up, write it out, whatever it is, and send it in. And the last thing I'll say, and we'll leave a couple minutes for a couple questions, is just, anything you can do to have the file completed and ready. That's the big thing. There's a 75-day notice requirement that was mentioned earlier. So if we have to continue a case, we can't ask you to waive that, but our judges are usually booked out months in advance. So we're already scheduling hearings now for September, late August, early September. So we don't want to have to make someone wait another 3 or 4 months just to come back because the file wasn't ready to go. So that's really the big thing I would stress. So with that, I'm going to kind of wrap it up and open it up and see if, I think we have a few minutes for some additional questions. Happy to take.
Thank you, Josh. Thank you, all of our speakers. That was all very wonderful and educational. We did have a couple questions. I think the first was, we've mentioned it, has the fee cap increased to $7,500, whether it's gone into effect, and if not, when it will go into effect?
So that was just announced about a week or two ago at the National NASCAR. And I'm sure, Rhonda, you can probably answer this better than I can, but it's a national organization of representatives. And I think that's where it was first announced. I want to say the cap was raised to $7,200. I do not know when that goes in effect off the top of my head, though. So
I don't know, but I think I heard some June, end of June or something like that. It's middle of this year. I know that.
Yes, so somewhere in that time frame. Unfortunately, I can't recall either off any more specifically.
Thank you. The second question was more about COVID-related hearings. Will there be any communication or documentation sent to litigants, claimants, representatives regarding back to in-person hearings? If so, and when? And then as a follow-up, will the claimants have the option of appearing via phone, video once in-person hearings resume?
Yeah, so in terms of manner of appearance, it's always up to the claimant. So those options are going to be there. The online video, the traditional video teleconferencing, as we open up, that will expand as well. But I do believe the online video hearing process is here to stay. Like I said, I'm a little biased because we kind of pioneered it out in the Seattle region, and we see a lot of benefit from it. I mean, we only have 2 hearing offices for the entire state of Colorado, right? It's a big state. We have 1 in Anchorage. It's a huge state. So I think this really does provide a great service to claimants who they don't have the means, or medically maybe, they're not able to really travel those huge distances, but yet they can still get, a better sense of hearing than they would do on a telephone. So yeah, I do think that that's going to stay and stick around and be part of the normal course of what we have to offer. In terms of the in-person, right now, again, it's very small number. What we're doing is we're scheduling people that have written us when we sent out, over the last year and a half, are you willing to do a remote hearing by telephone or by video? Those individuals that opted out said absolutely no, we will only do it in person. So we have a long list of thousands and thousands of cases of people that have been waiting going back to 2020 that want their in-person hearing. So we're working our way through those. And so if you take on a case, just discuss the manner of appearance options with the claimant. And, if they want it in person, then that is their right, and we will schedule it as soon as we can. I can't really be any more specific than that because we just don't know how well it's going to go and what's going to happen. I think in the back of our minds, we're all ready to go. We want to open up fully, but again, what we don't want to do is bring in someone who is already suffering from an impairment and expose them to COVID and have someone become ill. So we want to balance safety with everything as much as we possibly can.
Thank you. And just so that you know, in the chat, both Thomas Hill and Stephen Earle noted that The fee cap increase is effective November the 30th, 2022.
Good to
So
know.
it'll be November. And then I think I only had one other question. What is the current standard of practice to follow in order to get an ALJ to order updated medical records for indigent claimants?
I can speak to that, Judge, if you'd like. I want to say that if the case is repped, so you have a claimant, it's the representative's job really, along with the agency's job to request those records. The claimant's job is really to provide a list of who they see so that we know who to request. I mean, there are some out of the box judges, I'll just say it that way, that do some strange things, but for the most part, if the claimant has told someone that they need a record, I need to request it for them. And there's ways to do it. If I can't get a record, I will request, I'll just send a letter to the ALJ once I'm assigned an ALJ, and I will request what's called a HITMER, HITMER, but only certain medical records are connected to the HITMER system, like the bigger ones, like, I don't know, like Kaiser, UC Health. Judges can't even automatically get the HITMER. They will just request them on your behalf. But usually they're not going to hold that against a claimant. If there's a problem getting those records, that they're not going to hold that against a claimant. I can't say that's never happened, but I think I've had that happen twice. And then I write a letter in response, and that's just not acceptable. A claimant shouldn't have to prove if they're homeless, that they had to work really hard to try to get records. And also on that note, in Colorado only, we have the Laura Hershey Act that states, in short, that a claimant for these purposes should be provided free medical records one time. You can't keep asking for the purposes of a disability claim. So the claimant also should not be charged, nor should their representative. They should not be charged to get copies of these records, or at least not charged very much. Sometimes like $10 or $18 for administrative fees. But I've also given everybody my email in this chat. I'll be glad to help anybody through this or share any of my letters or briefs, redacted, of course. So keep that in mind. I have no problem with that at all.
So thank you. And we know, just in the interest of time, I want to make sure that we can clock off. But just make sure you read the comments in the chat. Most useful CLE that I've been to in years. Thank you so much for this great presentation. So again, I just really wanted to thank all of our speakers today for coming. And as has been the comment throughout, if you'd love to learn more about Social Security, disability, or income, please do think about taking a case with Metro Volunteer Lawyers. And we've got lots of support, as you can see, to help through the process. Again, Judge Kidd, Rhonda, Mona, thank you again for your time today. Thank you, Kyle. So have a wonderful afternoon, everyone, and thank you.